Welcome attendees to the Canadian Gas Association's webinar on new technology and Canadian energy regulators. My name is Paul Chiliak, Vice President of Strategy and Delivery with the Canadian Gas Association. We're pleased you're here and have taken the time to engage with us on this important topic. For those in the utility industry, innovation and technology are central to our evolution as companies who are continually meeting the changing needs of our consumers. Governments in Canada and the United States are looking to lower emission futures, including net zero by 2050. With it, the role of utilities and their regulators will be foundational. The traditional model and approach to utility involvement in new technology deployment has taken some very interesting turns over the last 18 months, driven by some landmark decisions in Canada. Similarly, we're witnessing a string of positive developments in the United States. We have with us today some of the brightest minds to help us unpack how regulators are thinking about their role in enabling new technology deployment across the utility system. Our moderator for today, Gordon Kaiser, will lead us through the session and will moderate the day. We encourage all of you to use the question function. Much of the added value of these virtual meetings comes from your questions and the dialogue that ensues. We are recording today's meeting. A copy of the recording will be sent to all attendees after the meeting. Thank you. Enjoy today's conversation. And Gordon, the floor is now yours.
Thank you, Paul, and thank you to the Canadian Gas Association for hosting this event. It actually had its genesis, its start as a program of the Energy Bar Association. We ran into some difficulties with the conflicting program, and the Canadian Gas Association finally picked up the mechanics and made this possible. As Paul suggested, what's at issue here is something that we believe will turn out to be very important in the coming years. We're looking here, this is a nuts and bolts type of session, and I'm pleased to see how many utilities signed in, and many of them bringing 5 or 6 people along. Because what we saw in 2020 is 6 interesting cases, well, I should say 5 cases, 2 in British Columbia, 2 in Ontario, and 1 in Nova Scotia, and we would call them technology pilots. Each of them varies a bit, and the authors of these decisions are here, and they will explain them in a minute. The authors that we have on board today are Peter Gurnham from Nova Scotia and David Morton from British Columbia. Joining us is Joe Kelleher from Washington, a former FERC chair, to provide the American perspective. I should say that we invited and tried to get the Chief Commissioner of the Ontario Energy Board here, but unfortunately she had a conflict with the hearing today that we couldn't change. There is a background paper that's available. It'll actually be published in the Energy Law Quarterly on 6th of July, but any of you that want it earlier than that, just email me at gordkaiser@gmail.com. The program is that we will proceed as Paul suggested, I believe, that with Peter, David, and then Joe spending 15 minutes describing their particular view. I will then have some questions for all of them. They then will have some questions for each other. And finally, but not least, the audience will be able to put whatever questions they want. If we run out of time, we will collect the questions that didn't get answered, and we will undertake to give you written responses. These are all seasoned regulators, and so they're all interested in and used to written IRs, so you'll get that as an additional benefit if we run out of time. So I think with that, I'm going to turn first to Peter Gurnham from Nova Scotia.
Thanks very much, Gordon, and thanks to Paul and the CGA for hosting this session. With respect to innovation, there may be a view among some stakeholders that boards can't or won't innovate. And my view is that our board can and does enable innovation within the envelope or playing field in which we're allowed by our enabling statute. I'm sure most of you know that as a quasi-judicial body, an energy board can only exercise those powers allowed under its enabling statute. In other words, if you're going to ask a regulatory board to do something innovative, it has to find a basis in law to be allowed to do that. Innovation beyond that may need the assistance of policymakers. The reason Gordon asked me to participate in this session is that our board, the Nova Scotia Utility and Review Board, in 2018 approved innovation justification criteria for innovative expenditures for electric utilities, principally Nova Scotia Power. I realize this meeting is sponsored by the Canadian Gas Association, but the best concrete example I have is with respect to innovation in the electricity side. I do believe, however, that the board would apply exactly the same principles for natural gas, and later in my talk, I'll just touch briefly on two innovative rate designs we have approved for Heritage Gas. So could you go to the next slide? Thanks. The innovation justification criteria enables the board to approve capital projects on the basis there's a reasonable expectation they'll provide customer value in some or all of the areas of reducing upward pressure on revenue requirement, reliability and grid stability, government policy compliance, or through the deployment of proven technologies in innovative ways. In addition, innovative capital projects may be justified on the basis that they're reasonably expected to allow for testing before deployment at scale and provide valuable data and learnings, or aid in the development of a business case where applicable. The most recent case where this was applied, and the case which Gordon has discussed in various publications, including the one he mentioned, involves an application by Nova Scotia Power for approval of a smart grid pilot project. The purpose of the 4-year pilot is to better understand how centralized energy system platform software can be used to monitor and manage distributed energy resources to achieve customer benefits, such as maintaining reliability and grid stability and reducing cost. In addition, the ESP platform has the following components. And can I have the next slide? So you'll see there's 3 sections to the pilot. First is solar. There's a construction and operation of a 2 megawatt solar garden. The installation of rooftop solar generation and battery storage at 4 commercial customer sites, the deployment of up to 200 in-home or in-business batteries, and the installation of up to 200 in-home or in-business electric vehicle smart chargers, and the installation of up to 4 vehicle-to-grid bidirectional EV smart chargers and the purchase of 4 EV vehicles. In the application, the utility asserted that the proposed pilot was justified under the second branch of the test you would have seen on the previous slide. In other words, aid in the development of the business case. A project falling under our innovation justification criteria differs from a typical capital work order usually undertaken by utility. In most cases, under the latter type of application, approval is sought based on a business case to meet normal operating requirements of the utility. Projects that are innovative in nature would generally fall outside what would normally be experienced in day-to-day operations. However, the board in its decision made it clear that projects falling under the innovation justification criteria require that some rigor be applied to the supporting material filed with the application. In this original application filing, the board was not satisfied with the initial application, as the initial application lacked supporting material, particularly with respect to the benefits of the project and the metrics to judge success of the project. We indicated that to be approved, a project must describe the knowledge gaps that the proposed pilot is intending to address, consider whether an alternative, less expensive pilot study could meet the same objective, describe how the proposed methodology was the best way to achieve goals, and adequately show how our innovation criteria was met. Much of the initial concern with the application was a very general nature, sparse in terms of detail about the project. Nova Scotia Power initially relied more on experience in other jurisdictions rather than analysis of what was planned on the ground in Nova Scotia and with Nova Scotia Power's partners. The board noted it might be tempting in some cases to simply try to adopt projects undertaken in other jurisdictions by other utilities in testing emerging technologies. However, useful resources and time may be wasted if specific measurable outcomes like metrics or successes are not clearly defined. In the smart grid case, through the course of the hearing, various concerns of the board and interveners were addressed through information request process and replied evidence. And the board showed what I thought was, and I chaired the panel, was a great deal of flexibility to Nova Scotia Power, which it might not do a second time round. Another application that doesn't have the detail required could be jeopardized in the early stages. Importantly, the smart grid project was also very attractive in that of the total project cost of 19 million, 11.9 million was being supplied by others, principally the Government of Canada, and small contribution by the province of Nova Scotia, and a contribution in kind by the municipality where the solar garden would be located. I think it's fair to say that the existence of substantial external funders helped persuade the board to find a way to be able to approve the project. In addition, this project was part of a larger collaboration which included New Brunswick Power and Siemens Canada on the Smart Grid Atlantic initiative. In the end, the board approved the project subject to filing of a detailed compliance filing, which dealt with some of the issues raised in the decision. We've also imposed fairly significant reporting requirements. Next slide. We've not had a similar type of application from a natural gas distributor in our province. However, we have made some innovative rate design changes for Heritage Gas. I'll just touch briefly on two of them, as recognizing this is a gas association meeting. Under the Gas Distribution Act, we approved a customer retention program for Heritage Gas, which permits it to adjust its base cost of energy for certain commercial customers within an approved range to allow it to remain competitive with alternative energy sources and keep those customers on the natural gas system. And to accommodate this, we suspended certain aspects of depreciation and allowed capitalization of OM&G costs. This was particularly to allow Heritage Gas to respond to low-cost propane, which was entering the Nova Scotia market from fracking activities in the United States. As I understand it, there's not a huge market for propane in the United States. There is in Atlantic Canada, and that propane was sort of being dumped in Atlantic Canada. The other is a residential retrofit assistance program, which set aside a certain amount of money as an aid to bridge the gap between a capital project's total capital requirements and the capital supported by revenue generated by the project in order to satisfy what we call our means feasibility test, which the gas company must otherwise meet to get approval for the build out of its system. And the purpose of the fund is to allow the utility to expand the natural gas distribution system to areas that wouldn't otherwise meet the means feasibility test. Next slide. So what conclusions are we to draw from all of this, our experience in Nova Scotia? Well, the first one, our board has adopted innovation justification criteria that enables innovation. So we've set the framework starting in 2018, where these innovative projects can come to us. And in the course of the decision, which I just referred to, we set out some considerable detail as to what we want to see in a future application. Any application for an innovative project must find a basis in the statutes that govern the board. So just because some minister makes a speech and says that this, that, or the other thing should be done doesn't give us the statutory authority to do it. Just because we've signed a Paris Accord doesn't give the board statutory authority to do it. So that has to be key to any decision the board makes. And as we made very clear in this decision, the application must be adequately supported and will be rigorously reviewed. After all, this is still ratepayer money that is being spent, assuming the application gets approved, and we have to apply some rigor to make sure it's a useful expenditure. And I have to say that in this case, third-party financing or contribution certainly helped the approval process. I think we didn't say this in the decision, but I'll say it to you. The thought of leaving $11 million of a $19 million project that others were going to pay for on the table probably edged us along to help approve this project. So I'll stop there, and I'll look forward to the question session and what the other panelists have to say.
David, you're up.
Great, thank you. Thanks, Gordon. Thank you to the Canadian Gas Association for inviting me this afternoon. And good afternoon, everyone, and good morning to those of you that are with me here in the morning. This is a very important issue to us at the BCUC, and I know it is to all of you. And but we want to make sure that we get it right. And I'd like to talk to you a little bit now about what we are doing at the British Columbia Utilities Commission to support innovation in our utility sector, especially in natural gas. But at the same time, to make sure that that ratepayers are not being asked to pay too much or not being put at too much risk. So can we move to the next slide, please? So it's clear there's a transition underway in the energy industry. And that's going to lead to an energy system and consumption patterns that are a lot different from the ones to which industry has grown accustomed in recent decades. What will be the impact of this on our two major sources of energy that our utilities deliver to customers, gas and electricity? Well, as you know, current federal government policy requires that by 2050, all electricity either be generated from zero carbon emitting sources, or that any carbon produced in that generation must be captured and either sequestered or repurposed. For natural gas, it means that either the natural gas is delivered from renewable sources, such as RNG or clean hydrogen, or that the CO2 produced in the combustion of natural gas is captured and either sequestered or repurposed. Natural gas distributors then are under increasing pressure to reduce greenhouse gas emissions. Policies at all levels of government impose ambitious GHG emission target reductions that directly call for the reduced use of natural gas. And increasingly, there's voices arguing for the elimination of natural gas. And some of these voices are starting to come from some of my fellow regulators. However, if you look, for example, in my province, at the amount of energy that's delivered by our utilities, and I took a look at some stats from last year as I was preparing this presentation, natural gas provided roughly 25% more energy than electricity did in my province. And it also delivered it at less unit cost. So that would mean that if we were going to replace natural gas with electricity in the next 30 years, it would mean not only stranding a significant asset, it would require building new electrical generation and transmission infrastructure that's greater than what we already have. And that's infrastructure that took a long time, say 100 years to build. And this is in an environment where large projects are increasingly risky. While there are voices that say distributed generation can mitigate that risk, I still think that would be a significant challenge. So therefore, what is the challenge then facing gas distribution utilities? And indeed, our society as a whole, because I do think that it's a responsibility that all of us have to meet these targets. And that is to transition the natural gas system to deliver a cleaner fuel and to do it at less cost than electrification. So what role then should we as regulators play in addressing this change? Move to the next slide, please. The BCUC, we are like our counterparts across Canada and the United States, we're primarily an economic regulator. And the essence of our regulation is to impose on natural monopolies a pricing discipline that competition imposes on competitive industries. We're often talked about or called a proxy for competition. We don't establish or implement government policy unless specifically tasked by government to do so. And I'd like to endorse what Peter just said. We don't see it to be our role to impose Paris climate targets on our utilities. It's government's job to take those targets that it's committed to and translate those into specific statute, into legislation that we can then follow as we do our work. We're technology and policy neutral. We see our role to be to protect ratepayers from unnecessary cost burdens, and that's very front and center of what we do. Just because a utility could fund a particular initiative doesn't mean that ratepayers should necessarily pay for it. Our role is also to ensure that our utilities innovate to address these transformative changes in ways that are appropriate to their role as monopoly suppliers of energy and utility services. They shouldn't be angel investors, as I've heard them described. The energy transformation will produce financial winners and losers, as does every business transformation, and regulators need to ensure that ratepayers are not losers. As regulators, we need to be keenly aware of risk and to whom it's allocated. For example, it would be more efficient for a utility to tap into the results of research done elsewhere than to undertake research projects itself. We also want to ensure that to the greatest extent possible, customers who benefit from a particular initiative will be the ones that pay for it. So with that as a backdrop, I'd like to highlight a couple of key initiatives that we've undertaken at the BCUC to assist our utilities in managing this transition. And those are our approval of a couple of projects, particularly for Fortis gas utility in our province. One is their biomethane program, or RNG program, and the second is the innovation fund that we recently approved for them. So if we can move to the next slide, please. The biomethane program. Fortis BC's biomethane program, which again also is interchangeably referred to as renewable natural gas, it allows customers to purchase all or a percentage of their natural gas supply as biomethane. As you probably know, biomethane is chemically identical to natural gas, but it's derived from farm and landfill or wastewater waste from wastewater treatment plants, and it's deemed to have zero or near zero carbon emissions. Biomethane is more expensive than, I'll call it, normal natural gas. So as a result, typical residential customers, they typically voluntarily take up to about 5% biomethane. 5% of their total consumption they nominate as biomethane, those customers that choose to take it. And while there's been uptake by smaller residential and commercial customers, the program has been particularly successful in giving larger customers who have ESG objectives more choice regarding the environmental attributes of the gas they purchase. And a benefit of that is that they're willing and able to pay more for the biomethane than an average residential or commercial customer, thereby ensuring that the incremental costs of the program borne by residential ratepayers are reduced. These larger customers take up to 100% biomethane, albeit at a reduced rate of approximately, some reduced portion of its cost, and the balance is paid for by all customers. So this program was first approved by us as a pilot program in 2010, and then it was approved on a permanent basis in 2013. It was originally set up with the intent that customers requesting this service would pay for the full cost of providing it. Further justification was found in the BC government's legislated energy objectives. We took steps early on to minimize unnecessary regulatory barriers for companies that wanted to supply biomethane by exempting them from the need to comply with certain regulatory requirements. And we still review the contracts that Fortis signs with its suppliers. Fortis's long-term biomethane, first long-term biomethane contract was with a university, and the suppliers of biomethane include wastewater treatment plant, landfill, and dairy farms. Through the 2019 GHG reduction regulation, the government stated that provided biomethane costs acquisition costs were no more than $30 a GJ, and volumes were not in excess of 5% of natural gas sales, Fortis BC could purchase biomethane, and if it did, it must allow Fortis to recover these costs from its customers. So there you have an interesting case where the pilot was, Fortis came to us with seeking permission to do the pilot. We approved the pilot, provided certain requirements were met, and then once the pilot was proven, then government stepped in and had a hand in commercialization. So we had a lot of chefs in the kitchen here, and as a result, a large part of the way that the commercialization has been shaped has been by government regulation. So a couple of recent highlights of note. One is that we've approved biomethane purchase contracts outside of BC based on delivery of notional biomethane. And this was to address a biomethane shortage in the province because on the cell side, the program is quite successful. We also recently approved first biomethane acquisition outside of Canada. While these out-of-province acquisitions do meet our provincial government's GHG reduction targets for BC, they do raise a potential for double counting of credits, both in BC and the jurisdiction where it's produced. In addition, standards for environmental credits, and indeed the nature of the credit, may differ from jurisdiction to jurisdiction, and that makes it difficult to ascertain if there is double counting. In our view, a regulated market for the exchange of environmental credits for natural gas would be very helpful. Secondly, government has recently updated the GHG reduction regulation with the key changes being that while the volume limit is increased from 5 to 15%, there will be an annual increase in the allowable biomethane price, and hydrogen gas and gas from biomass and black liquor are now also eligible. So move to the next slide, please. And lastly, I'll just talk a little bit about the Fortis's Innovation Fund. And that's a fund of approximately a little under $5 million a year that we recently approved for Fortis's natural gas operations. We approved the Innovation Fund for gas as we agreed that there is a demonstrated need to accelerate natural gas innovation activity to meet the climate change target set up by the province. For example, meeting Clean BC's target of 15% of natural gas to come from renewable gas will require 100 times scaling up of renewable gas supply from existing levels, a not insubstantial feat. In addition, we considered that existing alternatives for innovation left significant gaps in innovation funding. So our approval for the Gas Utilities Innovation Fund represents a key milestone in innovation funding. Previous applications were directed at specific projects. This application, however, created a fund for projects that would be that were not defined at the time of the approval, but that would be considered ongoing as we move forward. Identified investment areas included blending hydrogen, renewable natural gas, fugitive emissions reductions, and carbon capture. The fund is targeted to initiatives that are ready for feasibility research rather than basic technology research to increase the likelihood of customer benefits. And I would add also reduces ratepayer risk. Funded technology will be nominated by a special committee established for that purpose, with selection criteria including the amount of co-funding secured, estimated emission reductions, and energy cost reductions. Fortis will report on its results annually as part of its overall annual review, and costs are recovered through a fixed charge rate rider of 40 cents per month, and the rate rider is attached to the basic charge, so it's a flat rate independent of how much gas you purchase or have delivered. We expect benefits from this innovation fund to be cleaner, more affordable energy solutions, mitigating the risk of future rate increases for ratepayers, and supporting the long-term viability of the gas utility. Yesterday, I was part of a UBC panel to discuss commercial-sized carbon capture utilization and storage. The technology that was being discussed was a pilot project that's around the size of a commercially sized boiler. And in addition to capturing otherwise waste heat and flue gas for reuse, it actually turns waste carbon dioxide into a sodium carbonate that can be used to make pharmaceuticals, glass, and soap. The latter, I guess, that's an indication of truly clean energy. It was an interesting discussion and an example of the kind of innovation that's going on in this space. However, it also raised some interesting issues, which included, would this be commercialized as a utility-owned asset or a behind-the-meter option for customers? In order to count the emission savings on the utility side, it may have to be owned and controlled by the utility. But that's a good example, though, of the kind of small-scale project that the Innovation Fund would be suitable for. And in fact, Fortis did participate in a pilot for the carbon capture project I mentioned, but they did that under a similar fund that we had approved as part of a DSM expenditure schedule. So hopefully that gives you some of the flavor of a couple of approaches that we've taken to innovation pilots, and happy to discuss further and answer questions about them. And thanks for listening.
Joe, you're up.
Okay, thanks, Gordon. I want to thank you for inviting me. I'm not Canadian, so I'm going to offer the U.S. perspective. And so there might be some interesting differences, and that could lead to some discussion and questions. I do offer the U.S. perspective on the role of regulators and regulation on developing and deploying technologies, particularly technology whose purpose is not to serve the traditional goal of a public utility, but instead an environmental goal, lowering carbon emissions. And I do offer the perspective of both a former regulator as well as a former utility executive. So I've been on both the giving and the receiving end of regulation. So those are different advantages. But to me, thinking through this question, I think there's some threshold questions for regulators on how to address these issues. One, and this has been touched on by the first two presentations, is to what extent are carbon goals law, or are they merely policy statements? Two, is the regulator independent or part of government? Three, is the ordinary reasonableness and prudence standard that regulators apply nullified or subordinated to the government's declaration of carbon goals? Four, does the regulator have a role in both technology development and innovation? And by that I mean R&D as well as demonstration projects, and technology deployment, deploying technology that's been proven, or is it just, is that role limited to deployment and integration of proven technologies? And then lastly, how can regulators perform this new role? And I'm going to try to fly through those questions in my time. Now, on the first question, are carbon goals law? And the second question, regulators independent, part of government? I think those are very much interrelated. How should regulators balance traditional public utility goals with environmental goals, such as carbon reduction? And I think a large part of the answer depends on whether those goals are law and whether the regulator is independent or part of government. Typically, there is a separation of utility and environment regulators. They're different bodies. They're entrusted with different laws. And utility regulators don't set or enforce environmental law, except in a handful of U.S. states where the energy and environmental agencies have actually been merged. Now, President Biden in the U.S. has set very aggressive carbon policy goals. Those goals are not law. They are, and to the extent the president has issued executive orders, executive branch agencies under his control are obliged to act consistent with his policy direction if they have discretion under current law. For example, EPA has discretion to regulate carbon emissions. So if President Biden sets aggressive carbon goals, EPA should be expected to issue carbon emissions regulations. But there's a second branch of U.S. agencies, independent agencies, as well as Canadian independent agencies too. So not all agencies are obliged to act consistent with, not all federal agencies are obliged to act consistent with the president's directions if they're independent. At the same time in the US, governors from time to time, they also issue pronouncements on carbon policy, some of which have been incorporated into state law, but others remain vision statements, not law. And the same logic follows. If a state agency is an independent agency, the governor's policy goals are not law, but policy statements. To what extent are they supposed to act consistent with the governor's policy statements? So there are two types of agencies, executive and independent. Typically, utility regulators are independent agencies, not subject to removal except for cause. And if carbon goals are law, those laws bind both independent and executive branch agencies. But in the US, independent regulators are not bound by policy goals of government that are not reflected in law. FERC, for example, is not part of the executive branch, and it is bound by law, not presidential declarations or executive orders, and many state commissions are also independent of government. If when I was chairman, I was asked by the White House, or directed by the White House, to halt approvals of pipeline capacity expansions as part of a president's carbon policy, I would have noted I was head of an independent agency, not subject to presidential control, and I would have respectfully declined on the grounds that doing so was inconsistent with FERC's legal duties. The Supreme Court has actually held that FERC's fundamental duty under the Natural Gas Act is to promote the orderly development of plentiful supplies of natural gas, and halting pipeline expansion seems inconsistent with that duty. So if, as a basis of my refusal, I might have been demoted from chairman to commissioner, but I actually couldn't have been removed from the commission. Next question, is reasonableness and prudence standard nullified or subordinated to government's carbon goals? In my view, this really is the critical question that essentially dictates the outcome of regulator decisions on promoting carbon technology development or deployment through rates. If the reasonableness and prudence standard is nullified or subordinated to government's carbon goals, then it seems to me arguably any technology investment that is directionally correct with those goals should be approved, no matter the rate impact, even if the technology may be unsuccessful and fail to deliver the expected public policy results. I don't see any limiting principle to subordination and nullification of the reasonableness and prudence standards. So I think that that can't be true. My view is straightforward, at least in the way I think. I do not believe the ordinary reasonableness and prudence standard can be nullified or subordinated to government's declaration of carbon goals, regardless of whether the regulator is independent or part of government. And I think prudence requires more than a cursory review of proposals that seek to advance carbon goals. In my view, for environmental technology costs to be determined reasonable or prudent, there must be some consumer benefit, not merely a hope that a particular technology might further the government's policy goals. And where a particular technology advanced environmental policy goals but provided no consumer benefit, in my thinking, costs would normally not be considered reasonable and prudent. One example in the US is Virginia in 2019 rejected a filing by the principal utility in Virginia, a grid transformation plan. There's a 2018 law in Virginia that required that all state utilities require a grid transformation or modernization plan. This utility made such a filing, and it was a $6 billion filing. They proposed spending $1.3 billion on smart meters, $776 million on grid technology enhancement, and $3 billion in grid hardening. The state commission rejected almost the entire package. They rejected $5 billion of the nearly $6 billion in spending, finding that the package was not cost effective and would result in economic loss for all customers. The state commission found that the smart meter and grid technology proposals lacked detailed cost information and lacked any plans to realize customer benefits. And the commission rejected the $3 billion in grid hardening proposals based on a lack of showing of need for grid hardening on the proposed scale, any basis for cost estimates, and the lack of any plan on how the utility would spend the customer money. So I think there's some parallels here with some of the innovation fund proposals. Now, it's significant here that grid modernization wasn't just a state policy statement, it was a law. It wasn't a policy statement or a press release by a governor, it was a law. But even though it was a law, the independent regulator still required a showing of customer benefits. And I think that would be I think the Virginia decision actually decided things correctly. Now, does the regulator have a role in both technology development, which to my thinking again is R&D and demonstrations, or is it just deployment of technologies? Regulators are frequently described as barriers to innovation. The classic example is the lack of innovation in telephone technology before breakup of the phone companies, phone monopolies, and how the onset of competition produced incredible innovation in phones. I frankly disagree. I think that perception is a little off. I think it's strictly speaking that it's regulation that poses barriers, not regulators. I agree the quick adoption of technology, new technology, is characteristic of competitive sectors, not monopolies. But that's because traditional rate regulation encourages rate-based accretion through large capital investments. Regulation doesn't incent utilities to retire used and useful technology that is not fully depreciated simply because something better has come along. The premature retirement of assets that are not fully depreciated can be accommodated through stranded cost recovery if net customer benefits are demonstrated by the replacement of the new technology. I think that's much harder to prove when the benefits of the new technology that are replacing the retired assets are limited to meeting government's carbon goals, not traditional goals of public utility regulation. My view is that the regulator's role in technology deployment is much more likely to be successful than promoting innovation, if innovation here means R&D and a larger scale demonstration projects. I think small scale demonstration projects can certainly get approved. And I think R&D has been approved in the US, say through Gas Technology Institute or Electric Power Research Institute. If it's pooled and every individual utility's contribution is smaller, then that has been approved. It's been approved for the plain reason that it's not really challenged. So the amounts of money are small enough where it's not really worth the candle of anyone to actually challenge and perhaps litigate the approval of these modest sums. But with respect to technology R&D, I really think the question is whether there's a need for regulator to play any role, especially technology that's narrowly focused on environmental goals. And I'm personally not convinced it's necessary with respect to R&D. Most technology adopted by utilities receive no rate support at the R&D and demonstration stage. If you look on the electric side, electric combustion turbines, wind and solar technology, battery storage, those were all funded by vendors, not through rates. Now, as I mentioned, some innovations funded through Gas Technology Institute and EPRI, but those are fairly modest contributions that don't cry out for opposition. In the US, the US government funds very large-scale energy technology R&D, much more so than utilities. The DOE proposed energy R&D budget for the next fiscal year that starts in September is $6.13 billion. So that's just the energy R&D request. Now, when I was FERC chairman, actually, I entertained the possibility of a FERC role in technology R&D, specifically carbon capture and sequestration. I was aware that there had been a search that the Gas Research Institute used to be funded by a surcharge on interstate pipelines in the US. And I thought, well, could we do something similar? Could we impose a grid charge and fund CCS technology in the hopes that really under an energy policy rationale, not an environmental policy rationale, to maintain some diversity in our electricity fuel supply. And so I asked staff to analyze basically the threshold question. It was legal. Does the agency have authority? Does FERC have the authority to impose a grid charge to fund CCS? And as the staff was mulling over the question, I thought, well, if we were to do this, how would we do this? And I had tremendous doubts that FERC would be able to successfully exercise that role. Because it would, FERC just doesn't have technology expertise. It has many different kinds of expertise, but technology is not among them. Now, fortunately, the staff put me out of my misery by concluding that the agency had no authority to impose the charge and that the GRI surcharge was actually probably unlawful, even though it existed for many years. So that relieved me of at least the burden of trying to figure out how to exercise this role. Now, regarding innovation fund proposals, for the same reason the Virginia Commission rejected the grid hardening proposals, I find it difficult to see how a US regulator could make a prudence finding approving a fund in absence of a plan on how the monies would be spent and some showing of benefits. It seems to do otherwise to approve a fund and allow the utilities really widespread discretion on how to spend it. It comes close to delegating rate-making authority from the regulator to the utility. And I think to avoid delegation concerns, I think spending from an innovation fund would have to be governed by a specific plan or specific criteria, so that the utility role is arguably ministerial. There's been no delegation. And I think it's hard to see how that specific criteria would fit the needs or the concept of an innovation fund very well. Now, how can regulators perform this new role? As I said, regulatory agencies, in my mind, don't have technology expertise in general. So they're not in the best position to evaluate the merits of proposals to develop or deploy certain technologies. I think they're in a worse position to evaluate R&D and demonstrations than deployment. For the simple reason that the lack of any kind of performance record makes it difficult for the regulator to make a reasonableness or prudence finding, an ex-ante reasonableness or prudence finding. But I think there are ways regulators can compensate for the lack of technical expertise within the agency. And first of all, formal on-the-record proceedings. You hear both sides out, you weigh the evidence, you make a decision. Another option that at least exists in the US at the federal level for sure is the Federal Advisory Committee Act allows federal agencies to establish advisory committees for really any purpose. It's just the advisory committee has to be balanced. It can't be stacked in any interest favor. So FERC could establish a technology advisory committee, and that could advise the agency on which technologies are most promising to achieve certain ends, rather than and perhaps even looking at individual technologies. That's a way that you can get advice from the outside. Those meetings just have to be public so that there's nothing behind closed door. The agency can hire consultants that work for the agency, technology consultants. The agency can require that as part of any technology proposals that they approve, that an independent monitor be hired, paid by the utility, but really sort of working for the agency, reporting to the agency. And the regulator can also require periodic reports, perhaps annual reports on the results and the performance of the new technology. I do think that rate recovery is just more straightforward when technologies serve traditional goals of utility regulation. And I think it is different and harder. Not impossible, but harder. Well, it is much harder to get rate recovery, I think recovery in rates for technologies that would only advance environmental goals, especially if those goals are not law. Now, to the extent carbon policies are based in law, how do you balance these two? So if you still have the traditional, each regulator still has the traditional duty and goals of utility regulation, how is that balanced against these new carbon reduction goals? If a particular technology would advance government's carbon reduction goals, but increase rates 10%, should the regulator authorize rate recovery, just flat out approval, or should it reject, or should it modify the proposal, perhaps with more gradual deployment of the technology in question, require the adoption of different technology, which again would be hard if the agency itself doesn't have expertise, or simply reject and require the utility to go back to the drawing room and submit an alternative plan. If recovery of R&D and development costs, demonstration costs are allowed, do regulators rely solely on ex-ante filings, or is there need for ex-post review if the spending is ongoing? How do regulators assess whether spending on specific R&D has borne fruit, are prudent, and should continue or terminate? And is it imprudent for utility to continue to persist in spending on unpromising R&D? Now, with respect to, there's been discussion of pilot projects, and with respect to deploying technology, if there is uncertainty about whether particular technology can provide benefits, the regulator, of course, can approve the pilot program, reserving decision on whether to authorize deployment on a large scale, depending on results. Now, I may come across as too pessimistic on the ability to authorize approval of environmental technology and rates, and I'm really not, because I think in many cases, many carbon reduction technologies also do serve a traditional public utility need. So I think it's better if again, putting my former utility executive hat on, if I were making such a filing, I'd want to emphasize that firstly, the traditional public utility goal that is being advanced by the technology. And then if carbon policy is not law, I'd want to observe, oh, there's also a collateral benefit of achieving carbon reductions. And that would be easier. That would be putting yourself in the best position to get approval, in my view. So just in sum, I think it's generally easier for the regulator to approve technology deployment rather than R&D and demonstration projects. It's easier to approve smaller demonstration projects than really large ones. And there have been some very large, disastrous demonstration projects in the US in recent years. It's easier to approve recovery of technology deployment in rates where there's a demonstration of customer benefit. And it's much harder to approve technology that is only directed at an environmental goal where there is no customer benefit. So I think think of it as a continuum where there's certain guardrails, but I think there's space for regulators to approve many carbon reduction technologies. And with that, I want to thank you, and I look forward to discussion and questions. Thanks.
Thank you, Joe. So I'm going to put a few questions to two questions to both Peter and David, just to get their different perspective on the same question. And the preface is that in all likelihood, we have not seen the last of these, I'm calling them technology pilots. The fact is that both Canada and the United States have significantly increased their carbon reduction goals. They've gone from 25 to 50 in the US, and in Canada from 30 to 40. Federal governments have put a lot of money on the table, $2.5 billion in Canada, $2 trillion in the US. Now, just to both of you, and I'll start with Peter and then David. Both of you have been through these hearings. They're long hearings, long decisions. What would you do differently in the next decision compared to what you did in the decision that you just released?
Thanks, Gordon. I'm a big believer in technical conferences, and we did not have one in this matter. And in retrospect, that was a mistake because we had a number of parties in the proceeding, and the level of understanding of the technology was different. And it really wasn't controversial to understand the technology. It was controversial to decide whether it was the appropriate technology for Nova Scotia Power and whether it met our innovation justification criteria. So I would have brought the parties together without board members present, obviously, with board staff, the interveners, and all of their experts to put everybody on a level playing field with respect to the technology. And certainly I'd recommend the board do that in the future.
David, what do you think?
Well, I gave two very different examples, so I'll try and answer your question for each of them. So for the biomethane program, the one that we purposefully and looked at the specific technology, we didn't just fund a portfolio of projects. I would say one of the shortcomings with the approach that I wouldn't say that we took, but that we found ourselves in. And it's basically how we find ourselves all the time, and that is we look at the world through individual applications. We never really did look at the entire program. It had a number of different components. It had a component where there is a sale of RNG to customers. There is a component where there is a purchase of the raw supply, and then there is a component where there's people that made biomethane and supplied it to the utility. And all of those three pieces came into us in different applications. And given scheduling issues at our commission, and I imagine in most commissions, you can't always have the same commissioners looking at each application. We typically have small panels of commissioners that look at applications. So we didn't really get a holistic view of the entire program. It wasn't as if the applicant brought to us and said, we're going to have this program and here's what we're going to buy and this is how we're going to buy it and these are the people that are going to supply it, and et cetera, et cetera, et cetera. So it's always a struggle for us. We're always doing catch up to try to put all the pieces together. I would say that was one of the biggest shortcomings there. As far as the more recent decision where we funded an envelope of projects or potential projects, if you will, that's a recent decision. It wasn't a decision I was actually personally part of, so I can only speak in my chair position now. It's very recent. There were no actual projects on the table, and it will be reviewed annually. To the very good points that Joe made about approving those kinds of things, the utility is accountable to us for the spending. There is an external advisory council that's part of the governance structure of the program. The external advisory council consists of various stakeholders, including customer groups. And as I said, we will review it annually. So I guess come back in a year or so, and I'll be able to give you a more fulsome answer on that question, Gordon.
Peter, remind me, what's the review in your case? It's not an annual review, is it?
Of the smart grid?
Yeah.
Yeah, it's, I think half yearly, Gordon. They have to file half yearly reports, and those reports go to the interveners, and they have a chance to comment. And as you know, this is, or as I explained in the paper, or in the talk, this is part of a project that involves two provinces, Nova Scotia and New Brunswick. And Siemens is the founder of the technology. And they're also filing with us, usually on a confidential basis, because there are proprietary interests of Siemens. The actual work for the whole project in Atlantic Province is not, or the Maritime Province is not just the Nova Scotia piece, but we're getting those reports half yearly.
So it's interesting, at least with respect to BC and Nova Scotia, you guys are buying into some significant review obligations here.
Yes, that's correct.
One thing that, another question, my last question to both of you. Well, certainly in Peter's case, there seemed to be some difference of expectations as the application is filed. You got that sorted out. Do you think in both cases, whether it's BC or Nova Scotia, it would be useful to have some kind of guidelines as to the type of evidence that regulators want to see from applicants in cases like this? Is that going to be useful?
Yeah, well, actually, Gordon, when we wrote the decision, it's fairly long and fairly detailed, as you know. And what we were trying to do, and since you asked me that question, maybe we weren't successful, but what we were trying to do was set out a blueprint as to how we would administer the innovation justification criteria. So more than just dealing with the one application, we're trying to indicate to people who might use that criteria what the board expects. But your suggestion is probably a good one. We should probably draw from that a set of guidelines and attach them to the criteria themselves.
Well, yeah, but the thing too that's interesting about your case, Peter, is you had those justification criteria in place even before this case came along. It was part of
we
the
did.
capital review.
It was to try to bring some order to the process.
Yeah.
People had complained that regulators weren't inclined to approve innovation. So a board panel directed Nova Scotia Power to bring forward the sort of innovation criteria they thought they wanted. And then we had a proceeding on it. I wasn't on that panel. We had a proceeding on it, and the board finally approved the innovation justification criteria. But it was put in place to respond to a perceived need and to provide a framework to do these things.
Peter, this is a question for you. Unlike the others, I think I'm right on this. You had your own expert. Was that helpful?
It's very helpful, but you have to understand that in Nova Scotia, board staff don't go on the stand. So in order to get a complete record, board counsel frequently brings in experts to assist the board. And we have a regular arrangement with a company called Synapse and several others. It's a company headquartered in Cambridge, Massachusetts. And they're experts in things like this. And it was particularly valuable in this application because in addition to providing their own point of view, they provided detailed information in what was missing in the application, which I don't know that our board staff would have been able to assist us with. This was fairly unique, and they understood the technology. And so the fact that we were able to get to a complete record at the end of the proceeding, although it was a bit of a challenge to get there, was in large part due to the expert evidence we got from our own expert, or board counsel's own expert, but the consumer advocate who participates in all our hearings, he hired an expert as well. So we had two expert opinions in addition to the people Nova Scotia Power had that assisted in giving us a fairly complete record.
Now, David, you have a situation where you have one decision that allows the utility to go forward and dream up new technology. There's a fund, and presumably they come back to you. And even in Peter's case, or in any of these cases, there may be two steps. One is the initial pilot, if you want, and the other is the so-called scale-up problem, because the idea is if the damn thing is successful, you will move on to a second stage, if I understand it. How are regulators going to handle that second stage, the scaling up stage? Have you guys thought about that?
Yeah, it's a good question, Gordon. As I said in my remarks, as the biomethane program scaled up, our provincial government stepped in at that point, and they provided direction to us that basically required us to allow Fortis to purchase certain amounts, and we had to let that be recovered in rates. So that essentially set the amounts of biomethane that could go through the program. So, that was something that we didn't have, that part of it at least was something we didn't have to turn our mind to in that case. But so no, we haven't. We don't have any guidelines. I don't really have a lot of wisdom for you in that regard. It would be, I think, something like a utility coming to us with a capital project and an application for a CPCN. Those kinds of things don't originate with us. Part of the filing guidelines for a CPCN is that they're supposed to have looked at alternatives and come to us with the alternatives they've looked at and the one that they've picked, and along with a justification of why this is the best place to run this transmission line as opposed to over here or over there. And then at that point, it's our role to determine whether the project that's been applied for is a reasonable one or not. It's not our role to go in and examine the alternatives and tell the utility which one it should pick, and therefore which one it should bring the application to us for. So I would think that a commercialization should probably roll out much the same way. It would be up to the utility to come to us with a business case for what they've picked and why they've picked it, and what other alternatives they've looked at. And then we would have something concrete in front of us that we can examine.
Now, you turned down one of your two applications. I think it was the electricity one. Why was that?
Right. Well, the electricity one was for a lot smaller money. It was only around a tenth of the money, although that's not a reason for turning it down or not. But we did because part of the justification for both of the funds together was in the light of increasing electrification. And it was the panel's view that electrification wasn't a threat to the electric utility. That was the one that was turned down, and that the electric utility generally would benefit anyway from increased electrification, and government policy that would drive increased electrification would not harm the electric utility. And in addition, the panel found that there was insufficient clarity on what the nature of innovation, what exactly would be funded, what kinds of projects would be funded. Whereas on the gas side, they laid out that it was going to be, these kind, carbon sequestration and RNG and so on.
Joe, you've spoken about the federal perspective and your experience as being chair of FERC, but you also had a very senior position at NextEra, a big company involved in a lot of projects around North America, including Canada. From a utility perspective, not necessarily Florida Lake Power, but any of the operations of NextEra, what do you think of this notion of the ability of regulated utilities to go to a state or federal regulator and get this type of assistance? Or do you see this kind of thing happening in the US at all?
Yeah, I think pilots, I think there will be a lot of pilots in the next few years, because you're looking at the possibility of the greatest infusion of technology, particularly into the electricity industry, that we've ever seen, going back 100 years. And a lot of these technologies won't have a track record, won't be proven. So the utility is either just saying no, or it's allowing some kind of pilot, some kind of small scale demonstration. And I think it really comes down to scale, because if something's a small enough scale, it probably doesn't draw tremendous opposition. It won't have much of a rate impact. It won't draw a lot of opposition. As long as there's some potential customer benefit, that is separate from, than advancing some carbon goal, then I think the utility, the regulator can approve pilots of a reasonable scale. You mentioned NextEra, so one pilot that NextEra has right now, where they have a green hydrogen pilot, where they have a solar project that is frequently curtailed because there's other generation in that area. And their idea was, well, when the solar project is curtailed, let's use it to make, let's use that solar output to make hydrogen. And that transformed that hydrogen from regular hydrogen to green hydrogen. So it turns it into a different product that will have a different market value. And so from the regulator's point of view, well, you're making sure that something that's in rate base is you're finding another use for something in rate base. And the hydrogen that will be used at another NextEra rate-based plant, displacing some conventional fuel, right? So it just seems that to me is a really strong carbon technology pilot, but I also don't think that's difficult for a regulator to prove, because you say, well, something that's in rate base is going to be used more. We're getting more out of this, and we're displacing gas. And that won't have to be purchased as a result. And it's $65 million, so it's not enormous. And then if it's something that it proves out, it could be used at a broader scale at other solar projects and other companies. Yeah, there have been some. I mentioned a disastrous pilot where there was a lignite gasification project that was supposed to cost $2.4 billion, ended up costing $6.7 billion, and they ended up abandoning the gasifier. So they run it on conventional natural gas. So that was one where this technology had never been built anywhere. So that's a huge demonstration project. And now I don't know this technology. Is it impossible to do it on a smaller scale? Perhaps, but that was something that, boy, if I were a retail regulator, I would really hesitate over that. But I think there'll be a short answer. There'll be a lot of pilots, I think.
David, you had a challenge on jurisdiction, and you quite properly said, listen, this is about rates. We have considerable jurisdiction when it has to do with rates. And the problem went away. And Peter has pointed out, as has Joe, that the jurisdiction can come up in these cases. Now, just picking up on what Joe said, a lot of these distribution companies, Toronto Hydro comes to mind, they want to put storage in rate base. They want to use storage for the kind of things that Joe mentioned. Storage is an amazing asset that can take care of the variability. You can marry storage with solar, which is the big thing, and local distribution companies could use that. We're all thinking about it. What if somebody comes to you and says, listen, Mr. Chairman, we just want to put this in rate base, and if we can, it's going to help our carbon reduction goals. We don't want a rate increase, we don't want an additional charge. We just want to put it in rate base. Is that something you think you could handle, such a request, without a jurisdictional challenge?
Sure. For example, if there are legislated energy targets that the utility has to meet, and they can persuade us that an economical way of doing that is to combine storage with various other activities they do, then I don't see any reason why we couldn't do that, because it's in pursuit of a long-term cost of pursuing the fairly rigorous legislated environmental targets that they have to meet.
Some provinces, you wouldn't probably know this, Ontario is unique. They've recently had their objects, their statute changed to include innovation. So that gives them, of course, a peg to hang these things on. But do you see a jurisdictional issue in BC, David, with respect to how these requests might broaden out from the type of thing you've looked at, but a much broader thing of having, I'm thinking of distribution companies, I guess it's Fortis or BC Hydro in your case, saying we want to put this stuff in rate base and we'll go from there.
Yeah, frankly, I do think there would be a jurisdictional issue about what it would depend on what they want, what they do want to put into rate base. Generally,
storage. I'm trying to use that specific example.
Yeah. Currently, with the way things are in British Columbia right now, any, for the most part, any asset that would support the Clean BC program or various clean energy objectives in BC, things like everything from electric vehicle charging stations to CNG and LNG facilities for transportation. Those have all been by regulation that we've been ordered to allow them into rate base up to certain amounts. So it's not an issue that we've turned our mind or had to turn our mind to. So I think it would depend on the facts of the application.
But are you saying what you would need a specific direction or order from the government in order to put it in rate base?
I would think so.
Yeah. All right, I'm going to see if I can turn to the questions here and figure out what we have here on this. See if I have some here. Now, here's an interesting question. Given that there are separate acts and regulations for both gas and electric utilities, what is the panelist's view on joint applications that would be innovative? For example, utilizing excess renewable electricity for green hydrogen to be distributed on the gas grid. Somebody want to take a shot at that?
Yeah, I'll take a shot at it. I think it's a really interesting idea, and it's something that it's an issue that's arising in our jurisdiction. It's something something that my staff is looking at, and we've had requests from interveners to look at this issue too, and that is the fact that now we have separate planning, separate IRP processes that are conducted by the gas company and by the electric company, and there's no real attempt to try to coordinate between the two. And I think that there's a lot that could be done, short of a joint application. I'm not necessarily suggesting that, but I think that there's a level of coordination and discussion, and even just to make sure that forecasts align, to make sure, especially in a world where there's increasing electrification, because the customer that's targeted here is that it's the same individual that could be a customer of the electric company and a customer of the gas company. And if the gas company thinks they're going to keep selling them the same volume of gas, and the electric company thinks that they're going to electrify them in the next 10 years, then there's something then that's going to be out of whack with their resource plans, and that in itself would benefit from a regulatory review of how those plans are consistent. But it would also serve the goal that the questioner is asking too, and that is identifying, for example, identifying excess electrical energy and see if that could be used in the gas grid in some way, injecting hydrogen into it, clean hydrogen or something.
The next question is sort of related, but it flows from something Ontario has done. You may be familiar with it, you may not be. Ontario has created something that they call the Innovation Sandbox. It's sort of hipster language for, I would call it a technology guideline or a regulatory guideline, which is to say that if you can't use storage for something now, you can go and get an opinion from the staff, not the board, the staff, and they will, in some cases, give you an opinion. In some cases, can. In the first year, I think there were 33 applications, and I believe what came up was one opinion that one particular utility was granted the right to use storage, which had previously been denied with respect to certain objectives in terms of security of certain systems that had been, it was a regulatory clarification. I'm wondering whether, as you get into this business of these technology pilots, one question is the technology, does it have a merit and so on and so forth. The other is what is the regulatory barrier that may exist to implementing the technology. And I don't know whether these are two separate things, as they would appear to be in Ontario as that's evolving, or whether you guys would contemplate that as part of this hearing process, there might be a clarification on important regulatory issues. Is that something that you have contemplated?
Gordon, I'll start. And my understanding as to how the Ontario sandbox works is that people can bring projects and ideas, and without having to go through the full hearing process, get a reaction from staff and so on. I'd like to think that our staff does that. We don't call it a sandbox, but I think it's quite appropriate for staff to provide guidance, and not that it can bind the board, to people who are interested in innovation or anything else. So whether you call it a sandbox, I think that's a role the regulatory staff should play.
All right, and this may be a question for Joe. It comes from Adonis Yachu at the University of Toronto. And you touched on this, Joe, a bit, so this is your question. What lessons have we learned from the telecom revolution that are helpful in informing the transition occurring in electricity and energy?
Well, one lesson that I'm not sure we've learned yet, but stranded cost recovery. So, for example, in FERC, when FERC had its open access policies, it allowed stranded cost recovery because utilities had made certain rate-based investments of generation, almost predicating the assumption that competition would be limited because of their control over transmission. So there was a notion that that policy created stranded cost recovery was allowed. Now in telecom, I mean, I feel very antiquated because I actually still have a hard line in my house. Many people don't. And the people that don't aren't necessarily contributing to that system. And so telephone competition has been fantastic. You know, I remember rotary phones. I think my kids would laugh if they saw one and probably not know how it works. But I think there ultimately are going to be stranded costs in the telephone industry. And it could be that there's already been some stranded cost recovery. I'm not aware of it though, like it was at FERC. FERC knew its policy would create stranded costs and it acted at the same time, didn't allow that bill to accumulate for some future, you know, FERC chairman and commission to deal with. That's my top of the head reaction.
All right, thank you. The next question is from Ian Mondro with the Gowlings firm in Toronto. His question is there customer benefit in regulated utilities making investments in technology that preclude or mitigate the risk of future stranding of their regulated assets? Who wants to take a shot at that?
Well, I would say the answer is yes. I mean, I think regulators have to be open to anything that will assist in lowering the long-term cost of energy. And so I don't think we should foreclose the suggestion in Ian's question at all.
I think it raises I agree, and I think it raises an interesting point. And even though there may not be an explicit statutory basis to allow some sort of technology initiative to clean up carbon emissions on the gas system, if it satisfies that test, which is that if the commission is satisfied that there is a risk of stranding, and by making this investment, it is making this investment as a reasonable hedge against that, then that may provide the regulatory justification that may not be present just on the face of it for a clean energy project. put that to my fellow panelists, see if they have any comment on that.
I agree.
Joe, what do you
I
think?
agree too. I agree as well.
It's an interesting idea because the one thing we all know, if we've been in this business long enough, and I did a lot of telecom regulation first before I got into the energy side of this stuff. When these technology waves come along, and you are certainly going to see one in this industry, and there's lots of money floating around to bring them to the market. With that comes some stranding of assets, and local distributors, for instance, will have some serious concerns about if they don't modify their business to meet future markets, they're going to be out of business, and the customers will have stranded assets. So I have one last question for all of you that is a bit of a left field question. The question is this: if you had a local distributor, and when I refer to a local distributor, we call it Toronto Hydro, or if it was Edmonton, it'd be EPCOR, or Enmax in Calgary, or Electra in Ontario. If they came to you, or the local distributor in your jurisdiction came to you and they said, look, we got a mandate from our shareholders, in the case of those people, the municipalities that own them, the City of Toronto or the City of Edmonton or the City of Calgary, to be using entirely renewable energy by a certain date, whatever that is. And we want to put storage and solar to work. And we want to put it rate base. We want to generate our own electricity from renewable sources because we're not getting enough from elsewhere. What do you think the reaction would be at your board?
Well, the fact the shareholder wanted it wouldn't necessarily impress me, which was the premise to your question. But
Right.
I go back to the sort of overarching test that I think a regulator has to pay attention to, and that is lowest long-term cost. So if these technologies can, and I'm repeating myself, but if these technologies can assist in that regard, then I think a regulator has to be open to considering them. But simply because a shareholder wants to do something doesn't necessarily persuade me.
No, I only point to that was when I read these decisions, and I'm referring to the Ontario decisions that are not here, but the Ontario decisions, and this goes to Joe's point, they often said, well, the Ontario government's policy is ABC, so it wasn't that they had been ordered to do it, but of course David did the same thing. He's looking at the BC government's decision, and that appeared to guide him. Not that the mayor of Toronto necessarily knows anything about how to generate electricity, but we've had a hard line in this industry between generation and distribution for a long line, and it's been there for a while, and it may not make sense in future environments. And I just wonder whether you have, in your different jurisdictions, thought of this possibility. It sounds like what you're saying, Peter, is if a case is going to be made out that the technology will benefit the consumers of electricity in that utility's jurisdiction, then you certainly look at it. Is that right?
That's right. I think that's our obligation. Now, obviously, we'd have to look at any statutory limitations, but at the end of the day, I think we have to look at any technology that will create the lowest long-term cost.
I agree.
Joe?
Yeah, can I put a twist on your question? Let's hypothesize that the generation assets are pretty fully depreciated for the company in question, and let's say the solar resource is actually poor. That makes me think of, there's a great Alfred Kahn quote saying, utilities would build pyramids if they get them in rate base. So if a company, I would be very suspicious, I think. So what you're really saying is you want to make a large investment in rate base, right? Like let's put the saving the planet to the side. It looks facially like you want to make a big rate base investment in a technology that's not very good in this part of the world. Am I misunderstanding this? And it reminds me of, I was once on a panel with a governor from an East Coast state, and he looked at me during a break, he looked at me right in the eye when he learned I was FERC chairman. He said, I want my utility to make a big investment in offshore wind. How do I get them to do that? And I just said, put it in rate base. like put it in rate base, they'll build it, even though offshore wind is very expensive compared to onshore wind. It's like 4 times as much. I personally don't think it makes a lot of sense unless you're insistent on a fairly local resource, right? If you look at New England, offshore wind makes a lot more sense than onshore wind. It's still, if I were a New England regulator, I'd want to buy RECs from really cheap wind projects in the central, Northeast, rather than build offshore wind. But offshore wind's better than onshore. So that was a long way of answering it. But I would be suspicious, thinking this sounds like you just want a big rate base increase. Please persuade me I'm wrong. I'm thinking about this entirely wrong.
But Joe, surely the part of the regulator's job is to look at the technology and make sure it makes sense. I don't know if you've ever been to Nova Scotia, but Nova Scotia is not a great solar regime. So, but we're a terrific wind regime. So
Right.
I think that has to be taken into account. And for some policymakers, solar is the bright, shiny object. But it's got to be specific to what works here, and it doesn't work in the fog capital of North America here in Nova Scotia. So, but wind does.
Yeah, both of you are sort of speaking the David Morton line, which he keeps emphasizing that he's technology neutral. If it makes sense for the customer and is efficient, if it happens to reduce carbon, that's a good thing. But it damn well better be efficient and produce lower cost electricity than other alternatives. Is that a fair statement?
Yeah.
All right, well, I've run out of questions, gentlemen, and I'm mindful that David wants to catch that ferry. So thank you both, all of you, all 3 of you for this wonderful session. Thank you very much.
Thank
Thanks,
you.
Gordon.
Thanks all.
Thanks.
Bye.
All right, that will conclude our event. Thank you so much. Wish everyone a great weekend, and we'll talk to you all soon.
Thank you.